This Thursday, January 30th. And this morning, we're going to take up H 44 related to various amendments to motor vehicle impaired driving laws. And over to you, Ben, to start a walkthrough of the bill. Thanks for being here.
Sure. Thanks for having me. Happy Thursday. For the record, my name is Ben Novogroski from the Office of Legislative Counsel, and I will be presenting H44, excuse me, which is entitled An Act Relating to Miscellaneous Amendments to the Laws Governing Impaired Driving, which is a fairly accurate title, to be quite honest, because this bill proposes to make several changes really across the board, some technical, some not. So in general, the bill proposes language that the Family Division of the Superior Court reports adjudications of delinquencies and youthful offender violations related to impaired driving to the Commissioner of Motor Vehicles. This is supposed to be happening anyway. There are just some gaps in the law when it comes to specific cases, especially regarding those that are adjudicated in family court that are related to impaired driving violations. So this kind of is aimed to close that gap. Further, the bill proposes to align the impaired driving statute so that a person whose blood alcohol content is at the legal limit of 0.08 is actually considered a violation. As you'll see in 23 VSA 1201, 0.08 or more is the violation. However, in other statutes within that subchapter, it does not read the same way. It would say above 0.08, but not at. So it closes that gap as well. And then the bill also proposes additional language to ensure that a person's refusal to comply with a warrant for a blood sample could be prosecuted as a DUI refusal charge. And then the bill proposes to add certain definitions for terms that are used throughout, specifically like conviction, serious bodily injury, just so that there's no confusion of the use and meaning of the terms. And so that's kind of a general overview of what the bill is aimed to remedy, but obviously we'll get into more details as I walk through it. Any questions at the outset?
Go ahead.
So just to make this look a little bit nicer. We'll first start in section 1, which is the Judiciary Title for VSA in section 33, which discusses the jurisdiction of the Family Division. As you'll see here, there's a strike through on line 8 of juvenile proceedings because these proceedings can be beyond the term juvenile, and that's sort of an undefined term in statute really now. It's for children or youths. So just proceedings is going to be the operative term at this point. And then adding 52A, chapter 52A to that list of chapters, which is the youthful offender chapter. So that it would say that basically they have jurisdiction over these cases. And then you'll see in subdivision B farther on down, technical correction is regarding Superior Court, ensuring that all motor vehicle offenses are permitted to be disposed of in that court, not just misdemeanors. Some more technical corrections, and then you'll see here the addition of 335281 and line 19, which is the motion from criminal to family for youthful offender. So just to ensure that that process is captured within the court's jurisdiction as well. And you'll see here on the top of page 3, line 1 and 2, as used in this subsection. So anytime you see conviction will have the same meaning as in section 4, sub 60. You might be asking, what is that definition? I'm glad you asked, because what it means is an unvacated final adjudication of guilt or final determination that a person has violated or failed to comply with a law in a court of original jurisdiction or an unauthorized administrative tribunal. Now, that's really sort of the substantive language that we're thinking of here, because a lot of these, while they may not all result in criminal convictions, this would capture adjudications and criminal convictions as well. So just to ensure that that's captured throughout the statute.
So, and to be clear, when it's in juvenile court, family court, juvenile justice, it's considered an adjudication, not a conviction, right? And
Yeah.
but this definition in for 23 VSA section 4 includes adjudication.
Yeah, that language. So it's not adjudication per se, but I think that language of final determination that a person has violated or failed to comply with the law in a court of jurisdiction
Okay.
covers that.
Should that be clearer and say, use the term adjudication? I mean, in 23 VSA section 460.
I mean, we could, but this is,
Not necessary.
I mean, it's a policy decision. If the committee feels that it's,
Well, it just, is it clear enough? And I guess it probably is.
my read of it is that it covers it, but you could always be more direct and clear if you'd like to.
So maybe Marshall Dennis can weigh in on whether we bother with that or if it's clear enough.
Sure.
Thanks.
So then again, going into section 2, these are some of these definitions that I was discussing before. So serious bodily injury, and we'll get into where that's used later, resulting in DUIs that have resulted in a fatality or serious bodily injury. Just ensure that it's defined in this portion of the law so that there's no confusion. And just so you know, excuse me. The definition of serious bodily injury, which I do have in front of me, if I can find it, is multi-part. Hold on. I got it.
Oh,
Now you have it.
Thank you very much. You know what? It's really a team effort in this committee. So serious bodily injury means a bodily injury that creates any of the following: substantial risk of death, substantial loss or impairment of the function of any bodily member or organ, substantial impairment of health, or substantial disfigurement.
Is that in 13 PSA 1021?
Yes.
Barbara.
So then for the first one, substantial risk of death, and that was or one of the other things, right?
Yes.
So somebody could be charged because there was substantial risk, but there wasn't actually any.
No, so it's a bodily injury that creates any of the following, which is a substantial risk of death. So your injury would have to be so severe.
So it's, yes, thank
Yeah.
you. It's not just. Thank you.
Yeah, no problem. So going into section 1201 of Title 23, now this really lays out the bases of violations for our impaired driving laws. Become very familiar with these because we will continue to talk about these in other bills that are forthcoming. So the blanket prohibition you'll see in subsection A is a person shall not operate, attempt to operate, or be in actual physical control of any vehicle on a highway when the person's BAC is 0.08 or more, 0.02 or more if you're operating a school bus, 0.04 or more if you're operating a commercial vehicle. There are other bases, but really the 0.08 for our purposes on this bill is what's important because you'll see that the violation is 0.08 or more. So it includes 0.08. You'll see a lot of the technical changes, if you will that doesn't carry through, and this bill fixes that. You'll see here that there's some reformatting of the statute. So now there's a B sub 2. Because it really, and what this states is that a person shall not refuse to comply with a search warrant issued pursuant to subsection 1202F of this title. This subdivision 2 shall not be construed as impairing a person's right to challenge the validity of a search warrant and subsequent legal proceedings. So setting the stage here is that you can refuse a test. So, for instance, a lot of times when you're pulled over, you have your roadside test, but what we're talking about here are evidentiary tests. An evidentiary test can be breath, saliva, or blood. Now, what this does is that this creates a search warrant requirement for a blood test. But once a blood test is refused pursuant to a search warrant, it will create a criminal refusal. So you'll see, and we go farther down into subsection F, and you'll continue to see some sort of technical changes as we make our way down. Sorry. 1202F. So we're going to move on to the next statute F, not 1201F. My mistake. So in 1202, this talks about the consent of taking tests to determine the blood alcohol content. So there's Vermont's and most jurisdictions are implied consent. It's sort of this bargain between the state and the driver that for the privilege of operating a vehicle on our roads, you're also going to give consent through that action to certain testing. It's sort of this bargain. And you'll see here that under subsection 1 or subdivision A1, it says that the person has deemed consent for that evidentiary test of breath for determining the BAC of that person. Then there's also the blood test requirement that if breath testing equipment is not reasonably available, or if someone, if an officer has reason to believe the person can't give a sample of breath, maybe they're that incapacitated, that the person's under the influence of drugs other than alcohol, the person's deemed consent to have taken an evidentiary sample of blood.
Go ahead, Ken.
You just back up a little bit. So your headline there is blood test, right?
Yes.
And then we go right from there. The next thing is if breath testing equipment. So why we got blood tests there? I mean, maybe I'm being a little too picky here, but I don't get it.
Because if they're not able to give a breath test, or if it's not available, or if they're under the influence of drugs, because a breath test won't be able to tell the presence of drugs in your system necessarily. And then sometimes there are situations where a person physically cannot give a breath test because of suspected impairment, or maybe there's an issue with the equipment.
So just to be clear, my thinking, if you can't do the blood test or the breath test, then this is switching right to the blood test.
That's one of the bases to do it.
Okay, thank you.
So just to make it clear for myself as well. So the idea is that they've given implied consent for breath test. Breath test not available. That means we're going to consider that you've given implied consent for blood test.
Right.
Essentially. Okay.
Okay.
But the problem that we're trying to solve here with this is that a person has a right to refuse and demand a warrant for blood. And the way to think about this is that a breath test or a blood test is considered a search under the Fourth Amendment and Article 11 of the Vermont Constitution. And the way that this sort of, think of it as a graduated intrusion, if you will, is that a breath test isn't as intrusive as a blood test is. And so essentially the interest and the reason needs to be greater to have that intrusion on someone's body or their person. So that's why you kind of need to escalate this. You need a greater reason for a greater intrusion, sort of the concept here. So a search warrant may be issued and so this is the problem we're trying to fix with this. A search warrant may be issued either when a crash involving death or serious bodily injury, and the officer had reasonable grounds to believe that the person had drugs or alcohol in their system. It can also be issued when there's probable cause that a person is under the influence. A search warrant can also be issued when there's probable cause that is under the influence. I already said that. In the first instance, though, if a person refuses to submit to that search warrant, they can be charged with a crime of criminal refusal. And
Subsection F that you're referring to right now?
yeah, we're getting to that, but I'm kind of identifying the problem first
Okay, all right, thank you.
before I get to the solution, or proposed solution rather. So however, under the second circumstance, where there's probable cause, there's no refusal charge for first-time offenders, but they're often charged with impeding the prosecution, obstruction of justice, or contempt of court instead of a DUI charge. because there's no refusal that's tied to that basis. And so this is often, from what I understand, plays out in DUI drug cases rather than alcohol-based cases. So, and you should know that the penalties associated with those other charges. So if you can't be charged with DUI, which is a misdemeanor in the state, unless it's your third or fourth, those other charges of impeding prosecution, obstruction of justice are felony charges. So you can have up to a 5-year felony, and a penalty for contempt of court has no statutory limits. So a person would either be facing a misdemeanor DUI if we implemented this process in the DUI statutes, rather than the felony charge alternative for obstruction of justice or one of those other charges. And also, a conviction under those felony charges doesn't trigger that license suspension and the process to get your license back. So one could argue that it's not really getting at that rehabilitation issue of someone that may have been under the influence. As we talked about with IDRP, that's a requirement if you're a first or second DUI offender. So there's this whole process of the way our statutes are designed in the state is not only are you going to be held to account, but there's a process to rehabilitate you if you need it that is absent if you file those obstruction of justice charges or related ones. Does that make sense?
You good, Ken?
Kind of.
You want to?
Still learning. No, we're good. Still learning.
So what this does is,
Can you hold on for a second? Can you double check that we're on YouTube?
We are.
I tried listening on the way up.
Oh, just double check.
I couldn't yesterday either, Tom.
Yeah, just hold up it. Let's make sure that we're.
I figured you were having technical difficulties.
Yes. Oh, yeah, no. Yeah.
But that was my problem yesterday.
That's Judiciary, 9 a.m. 3 people watching.
Yeah,
We're all
no,
set.
yeah.
3 people watch.
Wait,
That's a
but
record.
Ann is here, so she's the one who's. Who are these? People are watching. Okay.
It's working.
All right, thanks, Coach.
Coach, from up on high. Yeah.
Yeah, Ian, go ahead.
So, it's a more invasive search for the blood draw. They're still going to need the warrant. They're still going to need to have reasonable grounds to request it. Either the blood, they can't get the breath test because the DMT isn't working, or they're not able because they're somewhere they can't get it, or the person's so incapacitated they're not capable of giving it. And you can't get a DUI refusal on a DUI 1 if they refuse the warrant on the blood draw. Yeah, okay.
But you can go after them in a different way, but
it's-
to get you into the DUI with the rehabilitation.
That's right, and it has harsher
And it's
penalties.
harsher penalties, and it's not really addressing the crime. That's, okay.
All right, thanks.
So you'll see here later on, in D6, that if a person refuses to take that evidentiary test, it may be offered into evidence against the person at trial, regardless of the search warrant. But the person may be charged with the crime of refusal now, and you'll see for a violation of 1201, if they're involved in a crash or collision resulting in SBI or death. And now adding subdivision C, refuses to comply with a search warrant that is obtained by a law enforcement officer pursuant to subsection F of this section, which says, and then you'll see in F1 here, that if a blood test is sought, and then we've added language, or I'm sorry, so it just connects that refusal of the warrant, and has just made it that criminal basis. So you can now charge it separately. So it's still within that DUI umbrella of statutes that have the lower penalties and rehabilitative component to it, as opposed to going those other charge routes, if you will.
Barb?
So then I'm just wondering, I understand that there are sort of gaming issues involved with why people refuse?
What do you mean gaming?
Like they don't want to be found guilty
Okay.
of like that, kind of like gaming the system, kind of,
Mhm.
not, yeah. But I'm wondering, like, are there other reasons that people are refusing where us not having people who for religious reasons don't want a blood test?
Potentially.
I mean, so I'm just wondering about penalizing somebody if, I mean, I'm sort of curious what the reasons are that people refuse it. And I do get when we heard from law enforcement and state attorneys, a lot of times it is,
Yeah.
they don't want.
Well, I would defer to them to answer
Okay,
that question. But what this does, this doesn't remove their ability to challenge the warrant.
Right.
So what it does is that it creates that refusal violation, if you will. But if for whatever reason the warrant is invalid or unreasonable, it can be challenged. And perhaps one of the reasons that they could propose is religious objection. But I would defer to
Okay.
my colleagues that do this every day.
Ian,
I just want to, Barbara, I appreciate the question. I want to say that choosing whether to exercise your constitutional right to refuse a breath test or a blood draw isn't gaming the system, right? Like,
Thank you,
it's-
thank you,
Yeah, it's an
Thank
important
you.
part of it.
thank you. Thank you for saying that.
So that's essentially the changes with that portion. Now, in section 1205, this is civil suspension, summary procedure. This is where what I consider technical corrections, but really can have a substantive impact of making sure that it's at the legal limit of 0.08 or above. So you'll see starting on line 13 right here, alcohol concentration at or above legal limit. So you will see that throughout. You'll see it on line 20 that the person's blood alcohol concentration was at or above the legal limit specified in 1201A of that title. 0.08, 0.02 if you're a school bus driver, 0.04 if you're a commercial truck driver. So that's everything that we're talking about there.
What does that technical change do?
It includes 0.08 itself.
So it wasn't included before?
Well, it was and it wasn't. So in 1201A, it was included, but in 1205, which outlines the summary civil procedure for a license revocation, it was not included. So one could technically argue that if you're subject to these civil summary proceedings and you blew a 0.08, you shouldn't have been doing it. Like you shouldn't have been subject to that process. So
0.081.
right, exactly. So this just closes that gap.
Thank you.
So you'll see that kind of throughout, along with some other technical changes just to gender neutral pronouns. And again, see on 13.3 at or above legal limit. So that's really, again, on line 13. I'm just going through it for all of you. And then you'll see here at the end that one of the issues is also notice to the commissioner of motor vehicles. So every time someone whose license is suspended or if they've been adjudicated of a civil suspension, that these notices that result from these proceedings have to go to the commissioner of motor vehicles. And you'll see here at the end that a copy of the affidavit of the law enforcement was really the sworn factual basis that follows these allegations of DUI violations, was previously required to only be sent to the defendant, but not to the commissioner. And that changes this as well, so that the commissioner of motor vehicles also has that factual basis for their records. Again, a technical change in subsection F reviewed by the Superior Court and just ensuring that the criminal division and the state's attorney's office get a copy of the notice of the intent to suspend, because that's, if you remember from yesterday, what happens is that if you are pulled over and there's suspicion of DUI, in addition to a criminal citation, you can also get your civil notice of civil suspension, which will say, basically you have to send this in within 7 days. If you don't, your license is going to be suspended on day 11, pending. But if you do send it in, then it's sort of delayed until that civil suspension is adjudicated. So this just makes sure that that notice goes to the criminal division in addition to the prosecutor, as is already the law. And there's a lot of language that I included here in this bill that's not changed, but I think it's important for the committee's just context as they read through the bill about what the process is. And so again, you'll see here another reference to at or above the legal limit to ensure that it's included. And then again, just more language and technical corrections of at or above the legal limit. And again, the presumption, so there are certain evidentiary standards, and there's a presumption that in any proceeding at any time within 2 hours of operating the vehicle, the person had a blood alcohol concentration of at or above with the proposal. It should be a rebuttable presumption that the person's BAC was above the applicable limit at the time of operating. So that's an evidentiary presumption, but again, consistent with the changes that are proposed throughout of including 0.08 and above. Any questions before we get into the penalties, which is
So 1201 is laying out the structure for the criminal penalty, correct?
Yeah, the violation.
The violation. And 1205 and moving forward, we're like in the civil world.
Yeah, so 1205 outlines the civil procedure.
So is it possible that instead of a inconsistency between 1205 moving forward and 1201, that there was it was intentional that 1201 on the criminal penalties should be 0.08 and above, but for the civil penalties, it should be only above 0.08.
I can't speak to the intent behind the differences. So
yeah, but like it, yeah, I'm just wondering, as we're like considering it, the sections we're talking about where we're talking about 0.08 and above, like that, I guess like the gap that could happen is if you had somebody at 0.08 exactly, and they, were found of DUI, they could be charged criminally, but the civil, they couldn't be charged on a civil.
well, it's also sort of a misnomer that 0.08 is the only way to,
Because you can, yeah.
because there's also sort of a catch-all violation of under the influence, right? And so you could technically blow a 0.03 and be charged with under the influence, which is still a criminal offense, because going back to the days before we had chemical tests and equipment, I think there's a case from 1933 that says slightest impairment.
Yeah.
And that's based off of physical observation. So the 0.08 kind of came about later on once the technology existed. So to distinguish it based on criminal versus civil might be a little bit of a misread in the sense, because you could still be charged criminally under the influence as opposed to 0.08, if that makes sense.
It absolutely does. I think I'm just trying to understand whether there was ever any like intent as far as those distinctions, or if it was just as the laws were being written, they kind of language.
I can't speak to the intent, but a point, 0.001 difference. I'm not sure.
Yeah.
I couldn't say what the rationale would be for that.
Yeah, absolutely. Yeah. Thank you.
I apologize if any of this was asked, but on the saliva testing, I realize this is existing law the way it is. So, and somebody can refuse a saliva test, I'm assuming, just like they can refuse refuse to blow, right?
Mhm.
Or refuse a blood test. So can a saliva test be ordered through a warrant?
I believe so. Yes.
I thought that was the answer, but
Because again, it's sort of that intrusion rationale, right? A saliva test is more intrusive. So really, a warrant is probably the safest way to go in a way, to present any sort of, to mitigate against any potential constitutional issue. Doesn't mean it eliminates it though. Any other questions before we go on to the penalties in 1210? All right, so in 1210, just to identify sort of what the problem that this section is trying to address. It's that these subsections were added 2007. I'm not going to try and do this. Where it was the intent of the General Assembly of Act 195 to address, among other issue, the Vermont Supreme Court's decisions in State v. LaBounty and State v. Martin. In LaBounty, the court held that if more than one person was injured in an alcohol-related accident, an offender could be charged with only one count of grossly negligent operation of a motor vehicle with injury resulting. Similarly, in Martin, it was held that if more than one person was killed, an offender could only be charged with one count of boating while intoxicated with death resulting. In Act 195 of 07, the General Assembly responded to those cases by amending various statutes to permit that an offender could be charged with a separate count of violating the DUI statutes for each person who was killed or seriously injured as a result of the offense. So that's what occurred in 2007. But regardless of that intent and those laws that were passed, the amendment failed to achieve the objective of subsections F and G to the extent that a DUI crash results in the death of a person and an serious bodily injury. They don't address the potential occurrence of both situations. And so what this tries to do is make clear that the enhancement related to those deaths or serious bodily injury for each person could be addressed in the statutes as well if it happened at the same time. So what happens here is that in subsection F and G, and you'll see in F2, if the death now with the addition of or serious bodily injury of more than person results from a violation of 1201 of this title, the person may be convicted of a separate violation of this subdivision for each decedent or person injured. So it includes the both situation. And then you'll also see that later on, sort of in reverse, but also another addition in this portion where if it results from a violation of 1201 and the person convicted has been convicted 2 or more times, the court may impose a sentence that does not include a term of imprisonment or that includes one of less than 5 years if the court makes written findings that serves the interests of justice and public safety. So that's the enhancement that goes on top. And again, to include a situation if both occur. Now in injury resulting, if serious bodily injury, and you'll see that I struck the definition of 1021. There's now sort of a small definition section to organize it better. You'll see there. And then in subdivision 2, serious bodily injury or death resulting. Again, capturing both situations. And then you'll see that the enhancement is that, so that subdivision 2 provides that it's a separate violation. Subdivision 3 is the enhancement. 5-year term of imprisonment shall be served and may not be suspended, deferred, or served as a supervised sentence. And there are other restrictions on furlough, parole, and other forms of release. You'll see here again the striking on line 4 of the cross-reference to serious bodily injury. So those are really the changes to that portion of those enhancements. And then in Title 33, this kind of goes to that reporting issue again, when we're talking about various, just ensuring that these orders make it to various people. You'll see, again, not only various people, but also that those youthful offender proceedings are captured in those reporting requirements since it wasn't explicit. And I have to say, as a former practitioner that did some criminal defense work and DUI, there was always a little bit of a hope with the clients that maybe the DMV wouldn't find out about the suspension because of these issues. But, so there's a little bit of a closing of the loop there, if you will. But you'll see here that the youthful offender status would be captured, child or youthful offender. And then in subdivision 3, which is added that notwithstanding notwithstanding subdivision 1, an order of delinquency or one that establishes youthful offender status shall be reported to the Commissioner of Motor Vehicles in accordance with those reporting requirements. Do have.
With the DMV not finding out, so the court would order it, but the information wasn't passed along? Is it that simple?
Sometimes, I mean, you know, it's, you don't know what happens sort of in the bureaucracy of it all. Sometimes with the criminal defense attorneys, sometimes it would happen immediately. Sometimes it would take some time. Other times you never really knew. But you would always advise your client that your license is suspended, don't drive. So there's that very practical reality. But as there was a lot of testimony previously, people still drive. And so whether or not that suspension was actually valid or not, was an internal monologue that maybe some defense attorneys would have.
Yeah, go ahead.
And you may have answered this, and I apologize if you did. For taking the definition out, or putting the definition in and taking the reference out to 13 VSA 1021, as like a practical matter, is it sort of the move to try to put definitions into statutes and not have them like reference definitions other places for a particular reason? I'm just thinking about like, so 5 years from now, the legislature changed the definition of serious bodily injury in 13 VSA 1021, and we're not thinking about the serious bodily injury definition here. And the intent is that this copies that.
Yes.
Is it better to have it reference that statute? That way it like almost like automatically updates the definition in this statute, instead of there needing to be some smart lawyer who says, "Oh,
Well, that's why we have our technical corrections bill.
okay,
Yeah,
well,
so
this is why I'm asking.
so if
Yeah.
those cross-references change
Yeah.
and they're not always captured in the bills that changes them, then there's an annual technical corrections bill that if someone's going through the statute and says, aha, wasn't captured, then it can be fixed.
Okay.
But I think sort of the conventional wisdom is that you don't want to have a bunch of different definitions all throughout the statutes. It's good to kind of have one base one. And yeah, it's a little inconvenient to have to flip back and look at it, but it's I guess it's also a policy decision if you want to have that, but from a drafting perspective, it just is an easier way to provide more consistency.
Yeah, that makes sense. Yeah, I was just curious. Thank you.
So let me just make also clear on this. So you're striking as defined in 13 BSA 1021-2 on page 19, maybe some other places. But that's because on page 3 in the definition section, you're saying the serious bodily injury, and it's it's as used in this whole subject.
Exactly.
And there it's cross-referenced to 1021.
So
I missed it.
so I went on earlier in the bill presentation. So and just to kind of tie it.
So in other words, if anything changes in for our definition of serious bodily injury, it is only changing one place, and then we have to cross-reference.
And because it's referenced in that first one, it's gonna
for the whole subject.
I apologize. I missed the definitions that we're referencing 1220.
No, that's okay.
That was good to point that out.
Yeah, and the other thing is that when you read the actual violation and reference a serious bodily injury, it reads nicer.
Yeah.
As opposed to kind of having so there are some
constant reference.
multiple benefits.
That makes sense. Perfect. Thank you.
Sure. And so now there's the merits adjudication. Again, this is in Title 33, which is the youth and delinquency statutes, that any disposition case plan that would involve this shall be sent to the commissioner and to the court in accordance with those reporting requirements. And the act takes effect on July 1st, 2025. If it passes out of committee, the House, Senate, and is signed. Let into law without signature.
Any other questions for Ben at this point? We may have others as we hear testimony, certainly, but doesn't look like we're good for now. Ben, thank you for the walkthrough.
Yeah, sorry, it was a little clunky because, you go in order of the statutes, but then as you indicated, oh, we dealt with this on page 3, but it's really kind of solving the issue on page 17 or 19.
Before the session's done, we're all going to be experts on DUI laws.
That's right.
So we'll have Dennis Weichman. Did I say it right?
That's how they pronounce it over there
Well, you would suggest that. I want to,
it's also spelled differently when we got here.
Oh, okay, all right. Well, in that case, Dennis Wigman.
Thank you, sir.
He clarified that the other day. I think I remember that.
Yeah,
Sometimes I pay attention.
there you go. Thanks for having me again. With permission, I'd like to first address perhaps some of the testimony that was given yesterday by Willa Farrell with regards to my testimony the previous day, and
Okay,
may have been a misinterpretation, if I may be so permitted,
go ahead.
and to provide some context to it.
I'm going to have to refresh at least my recollection of what you said and then what she said. You're now going to.
And I don't want to get into a tit for tat because I don't think that's very productive, but I just wanted to make clear that nothing that I said on Tuesday should have been interpreted as that I don't support diversion as an appropriate intervention with regard to DUIs. In fact, all DUI interventions as they've been practiced thus far have been relatively bad at addressing recidivism. All of the research shows that is the case. The worst, is jailing. Actually, it has a negative deleterious effect on recidivism rates, but it also keeps the public safe. And so as a specific deterrent, especially for those who receive their DUI 3s and above, it seems to serve an excellent purpose at that specific deterrence. And it should also be noted that when you receive a DUI 3, and I'm talking about not technically, because we don't have a lifelong look back any longer, it could be a DUI 1, but it's actually your third offense. And nationwide, third offense and above, pretty dangerous for our communities. You're seeing a roughly 60% recidivism rate amongst the person that gets their third DUI on a lifetime.
That's great. Barbara, then Ken?
Dennis, can you just send us the research that you're citing? That's what
I could send you some. It's a very, very large body of research. It's many years old. And I was going to get into what some of the new research has been showing and how I addressed it when I was state's attorney, if I could.
great. Just any research
Sure.
that you're.
So what has been learned recently, and when I was state's attorney in Addison County, I had read an article about Iowa. Iowa was perplexed by the fact that they were sixth in the country for recidivism rates in 2014. I bet you can guess which one was number one. Vermont. Unfortunately, it's only pays for these studies once every 10 years, and we haven't yet gotten the 2024 study. I expect the fact because there's a direct correlation between look back periods and recidivism rates. The longer your look back period, the higher your recidivism rate is going to be. We have some states that have only a 5-year look back period, and so their recidivism rates look a lot lower. And as they count them as how they are charged, not necessarily looking at a person's lifelong history. So in this Iowa program, they learned that intensively supervising and treatment focused DUI interventions seemed to be resolving better. They had decreased recidivism by about 24%. Subsequently, there have been a couple of studies, one published in 2024, that has reflected that, and especially in your first-time offenders. Now, what I mean by intensive supervision is essentially a sober buddy. They have folks from DOC or even from diversion who are checking in with the person regularly over a 12-month period. This is much greater than the average interventions. Average interventions nationwide are 3 months or less. Our interventions generally for DUI ones have been in the form of fines. It's usually just a $300 fine, have a nice day. IDRP serves that, intervention, if you will, that purpose of rehabilitation.
And how long is the IDRP
It
program?
varies depending upon the individual and their needs. Another problem.
IDRP, I'm drawing a blank.
Oh, that's the rehabilitative program for alcohol abusers, that, DMV, and I'm not sure if it's Department of Health, I think now that actually, handles it. Used to be in DMV years ago. Yeah, it's a, and those programs are, relatively effective because people want to get their licenses back and they engage. So I'm not anti-diversion in any way. I think that diversion is not necessarily a bad idea for DUI ones because at least there they have the board of community members that's going to talk to them about what they did, and that goes to one of the problems in determining risk for DUI offenders. I heard something mentioned about them being largely low risk offenders, and that's absolutely contrary to all of the research. DUI offenders are amongst the highest groups of offenders who are likely to commit another like offense. And as I said, third time, 60%. That's a very high number, a very high number. One of the problems that people might find confusing is that our folks here in Vermont tend to use the Ohio Risk Assessment System. That's a generic risk and needs assessment system that attempts to address all offenders as if they were one. And so they looked at commonalities between all offenders and created a way or a means by looking at those things in common. And then they can say, okay, this person's high risk, moderate risk, low to moderate risk, and low risk. Okay. There are DUI specific instruments that do a much better job because DUI offenders are extremely unique in that first, they almost only commit DUI and vehicular offenses. Second, they're much more pro-social than other offenders. They have, by and large, steady jobs, steady relationships. They're generally pro-social. They also have a higher rate of mental health disorder and substance use disorder. Depression, anxiety, and PTSD are high, found in a high number amongst DUI offenders.
So who gets to decide, remind me, who gets to decide?
Well, it would be,
risk analysis.
corrections or, in this case, the Attorney General's office, depending upon what instruments they've chosen to use. There is a fellow that's federally funded that goes around the country and teaches the use of these instruments, and they're free to use. And they're really more specifically designed to address DUI offenders.
So has the Department of State's attorneys taken a position or advocated for using one of the DUI specific risk analyses?
I think I'm doing so today. Yeah, I think it's a much better instrument. They've shown much better outcomes in other states that have adopted them. And because the point being that if your risk analysis, which ORAS does, is based upon antisocial behavior.
And ORAS is the Ohio
risk assessment system that's used now. If it's focused on those commonalities and you have a specific subset where those don't generally exist, they're always going to be low to moderate risk. I had a case in the last year that I was state's attorney in Addison County where a fellow had committed his 6th DUI in 5 years and he was low to moderate risk to reoffend.
So this isn't, it's not in statute as far as the.
It's not.
ORAS.
It's not controlled by statute. And I don't know that it necessarily needs to be controlled by statute, but I'd like to see people make better decisions and positions of deciding. I know it's another instrument that has to be used and learned, and that takes time, but I think it would go some way towards addressing our recidivism that.
And I just want to clarify, you said DOC or the Attorney General's office. Do you know for sure which one has decided on ORAS?
Well, I know DOC has decided on ORAS, and it's an excellent instrument. Don't get me wrong, for
other
generic purposes. I'm just assuming that the Attorney General's office uses the same instruments when they're addressing diversion and individual needs.
We can reach out and.
Yeah, another instrument that they might be using is called the Simple Screening Instrument for Substance Abuse. Now, in the ORAS, they do ask a person about their history of substance use. Try to see, do we need to look further? Corrections uses what's called the SSISA, which is a simple screening instrument for substance abuse. I recently looked into this instrument and its authors, until this would have been in December. Up until December, it may have changed since then, but up until December, it's not a validated instrument for substance use screening, and they actually advise you should use another instrument in conjunction with it in determining whether or not a person might need further, more in-depth screening for treatment purposes. So if either one of those, they're using the wrong tools to learn.
Before you head out, Ken, there's a question.
Sure.
I need to be re-educated.
Sure.
A DUI one that went to diversion,
Yes.
that could disappear if they pass diversion.
Correct.
That gets sealed,
At this point, it would get, expunged.
expunged. So how do we go from, okay, that gets expunged,
Mhm.
but then you jumped up to like 3, and it's like, well, wait a minute. Okay, so 1 got done, but 2 didn't get done. 2 would, I don't think it brings back out number 1
It does not.
because it's expunged at this point.
Correct.
Do,
Say what?
the do-over, you don't want to get.
But I thought I thought that was corrected, so we didn't keep enabling these habits to go, and then we're up to 3, we're up to 6, we're up to, and it
So-
continues.
That's where the civil comes into play. And so civils keep track. Okay, so you still get the 1, it stays. And in my diversion program, a predicate was you had to accept the civil consequences so that we could keep track. So there weren't people that were just, getting do-over after do-over.
So your next one is a DUI too, because you have the record in
On the civil side, right? If
You have
they're,
a criminal DUI,
Right.
but you have a DUI 1 that counts, and you're going to be DUI 2 if you get caught again.
right. And it's important to, in civil
We're
side,
not-
on the civil
Okay,
side,
so
which
I
is
got-
where your suspension occurs.
Okay, so I got that, right? So we get to DUI 3, 4, 5, 6,
Right.
and we know we got with a lot more of that. You're saying it doesn't help at all to lock somebody up for a while?
It does in a specific deterrence sense because those people are going to still drive. And one of the commonalities amongst DUI offenders is they tend to minimize the impact that their substance use has on other people and themselves. In other words, oh, I'm fine. What I'm doing doesn't hurt anybody, et cetera, et cetera. Much more likely amongst DUI offenders than all other offenders.
So I don't think that clearly answers that question. I think.
I was gonna ask that question myself, but go ahead.
Well. No, so the person, the incapacitation, you're keeping them off the road during the time they're incapacitated.
Right.
But that doesn't mean once they're out again, you've
Address it.
modified or addressed the
The
situation.
behavior. Yeah. Cognitive therapy has really been shown to be the only thing that really works because you're dealing with people that often, almost 60% have substance use disorder. A large number of them also have co-committant mental health disorders that need to be addressed. And that's why it seems in the latest research that longer term intensive supervision and treatment is what may be the best course.
Yeah.
Go ahead, yeah, please.
So in my mind, we're not getting these people the help they need. That's where we're failing as a state of Vermont of not following through. And we keep putting it out there, putting more of the public in danger of these people that keep reoffending. Because if they can be, get off,
Rehabilitated.
then we'd actually make some headway. And that's where we're failing immensely, correct?
I don't know. I wouldn't categorize it necessarily immensely. I think we have, good company,
What do you mean by good company?
it's virtually existent across the country because our responses by and large have been inadequate.
Okay.
And just to make a comment on that, yesterday we were looking at the IDRP program in the afternoon. And one of the issues that was pretty clear is that there are many individuals who can't take advantage of that program because they have to pay a fee and they can't afford the fee, so they end up driving without a license and probably repeating, driving impaired. And that's one thing that bill we're still looking at to see if there's something we can do about that. To get that treatment, which seems to be the only thing that could really help. So Barbara and then Ian.
I mean, another factor is because,
Oh, Tom, did you have your hand up as well? I apologize. No. Barbara, Ian, and Tom.
so I know from working in the field that it's the same thing with people who present with substance abuse issues in terms of denial and minimizing. And many people have that underlying problem that you were talking about and can't access, or the stigma of accessing treatment keeps them from getting the help they need so that they're not driving drunk. Right?
Snowballing problem.
Right.
Yes. The difference being that with our DUI population, there is a group of people who have, the same issue in their lives, but then they have the self-control not to get behind the wheel. And with our DUI population, for some reason, they can't put two and two together and realize this is really risky behavior.
So I know we looked at in this committee many years ago, like, could we have breathalyzers in bars? Remember, we had a lot of discussion about, like, if people were and I know, breathalyzers aren't that accurate if they're not maintained, like the bar situation. But again, I'm just wondering what we can do to raise their awareness before they're getting back in their vehicle. Anything that,
yeah, I mean, it's
yeah, I mean,
education is one of the best.
Like sort of the free ride programs have been successful in some places, right?
Yeah, especially the ones that have been targeted towards certain holidays.
Right, which
St.
is
Patty's
cheaper
Day.
than incarceration. But I'm wondering, like, what came up for me is how much people are willing to be forthcoming in their assessment. Not, I mean, it's, so
That's
I don't
the
know
larger
if there's, I mean, there are assessments where it's like your boss, and I mean, that probably wouldn't fly for this, but you're getting your boss, your father, your mother to fill out a survey as well. And that's like for other types of mental health issues where they're looking like you're falling asleep in school. So you're not, that, I mean, obviously these assessments are only as good as denial, I guess, right? Like, I haven't looked at these tools.
Well, ORAS instructs the person who's actually doing the scoring that they can exercise some discretion. And certainly if you have somebody who you've seen 3 times with a DUI in the last year, you're allowed to, say, well, I'm not really taking your word for it.
Right.
I think you probably need a further assessment. Yeah. And I wanted to also just make clear that we're talking about alcohol offenders. All of this research and so on is really focused on alcohol offenders. We don't know much about whether or not our DUI drug offenders will act or diverge in a similar way.
Ian and Tom. Yeah.
Sure.
Yeah.
Oh, Tom.
We got away from
Tommy and
topic a little bit, but back, if you don't mind. I want to just make sure I understand the DUI 1 expungement situation. So if you get a DUI 1, you successfully complete your goals, you can have your DUI 1 expunged. If you get caught again, that is now going to show as a DUI 2. And now I know there's a criminal and a civil side, but that's going to show as a DUI 2?
If it only on the civil side, if you've received a civil, which again is for refusals and people that meet one of those 3 numbers that you saw on the screen earlier, 08, 04, or 02.
Right.
There is no DUI civil for drug unless there's a conviction.
Right. Okay. But I mean, just straight up DUI, alcohol, 08 or above, DUI 1, I do what I need to do. It goes away. I get picked up again.
Yeah.
What is it?
A DUI 1.
It is a DUI.
Yeah.
Okay.
And if you committed like a reviewed a case on
But if
Monday.
there was a civil side, see, and this,
Right.
the reason I ask is because I've seen this before. People on the side of the road and scratching their head because you run them and you got them stopped for a DUI. I see a civil suspension that's alcohol related, so I'm assuming automatically they've had a DUI before.
It's a possibility.
Yeah, I mean, that's,
Because also we were talking a lower evidentiary standard, right?
Right.
Beyond a reasonable doubt.
they did suffer a suspension, alcohol related, or
Yes.
could be under suspension for, okay.
Yeah.
No, I'm good. Thank you. I appreciate
So,
it.
so I hate to ask this, but I'll ask it anyway. Just let's follow up to that. So they're dealing, we dealt with expungement and sealing last year and they're taking it up in the Senate. Is this something where if that bill passes along the lines of what we had here, maybe you don't have an answer on this, that information about that criminal DUI would be available for prosecutors to determine that the next time is not back to DUI 1, it could be
Yes.
DUI 2.
Yes, if it was sealed as opposed to deleted, then, I mean, for all intents and purposes, sealed, it can be expunged, so it's only being used for that purpose. But yes, that would make it visible on the, record check that's being run by dispatch or that's then made available to not just the state's attorney, but also to the court. So they would know as
I
well.
think that also, we did talk last year about that might take away some of the incentive to go to diversion anyway, if the DUI one was still hanging out there, even if it was sealed. But that's something we'll deal with after crossover. But Tom.
I just on that same exact thing, like if I run you in DMV, I'll see that civil alcohol suspension. That if I run you in Valcourt, I'll see the DUI 1. So.
Well, you'll see that.
If it's sealed.
They were pulled over for it, but you wouldn't see what.
Well, right, but
what happens.
no, you can see the charge, but that's where it'll stop. I wouldn't know where
That is diversion and.
Right.
Where it went.
the affidavit and everything will be in there.
And I would say the only shortcoming is the one thing that I was attempting to address on Tuesday, that state's attorneys don't know by looking whether or not someone's been referred to diversion. And I've heard from some state's attorneys and from some law enforcement officers that people have been involved in at the same time, not 2 or 3 times down the road, but all at the same time, 2 or 3 diversion or diversion-like programs, because some of the state's attorneys have their own programs. There's no single repository where you can look and say, oh, this person's already been offered diversion and they're in it right now. So the person might be offered it, but hasn't yet accepted it. But and hopefully it sounds like Willa believes that the Attorney General has a good handle on those people that are actually in the official diversion. But again, we don't know if they have or have not. And we are learning, at times, well after the fact, because of somebody's been arrested a second time, that they really have failed diversion, and the diversion offices hasn't informed the state's attorney's office that the person failed.
So Ian and then Tom.
So I just wanted to clarify, just because we had sort of this question yesterday, I think it was yesterday or 2 days ago, about, so if you successfully complete diversion, so we heard that people who go to diversion, often they have to plead civil. But if they successfully complete diversion, the civil is still there, correct?
It can be, correct. It depends upon the discretion of the state's attorney, whether or not they want to, impose the civil.
Well, no. So that's not my question.
Okay, sorry.
So my question is, if they plead to the civil,
Yes.
if they successfully complete diversion, is the civil still there?
Sits there.
Okay.
Yes.
And so you can get an instance where they get pulled over again, and now they're charged with a DUI 1 criminal, and they're charged with a DUI 2 civil. So you get a 90-day hard suspension, 118 month. Yeah. All of the, okay. And then we heard some testimony from another witness that the vast majority of DUIs do not go through diversion.
That is true.
Okay.
Yeah.
Yeah. All right. Great.
Yeah.
Thank you.
Yeah. And as far as suspensions are concerned, research has shown that the suspensions that are the most effective are 12 to 18 months. And we're talking very small percentage numbers, though. We're talking like 4 to 6% improvement.
And just one more follow-up. Also, we talk about prosecutorial discretion. Do you see sometimes that a prosecutor might lead a DUI down to a negligent operation, but have them plead to the civil so that they have that record?
I can only speak for myself. I've done that for sure. Yeah.
And what was your reasoning?
Minimal facts, right? Otherwise, fine operation, no criminal history, a willingness to engage. Yeah, I think they'll probably do well in the IDRP, that sort of thing.
Yeah. So, great, thank you.
But not all of our prosecutors have the time to focus on these sorts of things. 365 cases is a lot. And so being able to actually dig into every single person's individualized needs, that might give you some insight into why I'm not the state's attorney any longer, because I was running myself ragged. So,
All right, so are we about to get to the bill?
yeah, let's do it.
Take a 5-minute break, so we'll go off live,
Thank you.
which, of course, it's 10 minutes. Are you gonna call it 5 minutes?
Meeting with Nutter today?
Yeah. Which reminds me, I'm gonna turn off our list bills.